Welcome to Workers' Comp Update with Joseph and Sally. Joe is a partner in the Chase and Sally Law Group and is also treasurer of the New York Workers' Compensation Alliance, dedicated to serving the needs of injured workers throughout New York State by lobbying their interests in Albany.
What is the New York Workers' Compensation Alliance?
Okay, the Workers' Compensation Alliance is a political action committee, and it's comprised of a group of attorneys throughout New York State, solo practitioners, partnerships, law firms, larger law firms. And the purpose of the Workers' Compensation Alliance is to lobby the interests of injured workers up in Albany, respond to proposed changes and regulations that could affect injured workers here in New York, and recommend changes to those recommendations. So right now, that is actively being discussed here in New York with respect to one aspect of the statute that provides benefits to injured workers.
Joe, what is workers' compensation?
Workers' compensation is primarily social legislation here in New York. Many states have workers' compensation statutes, but again, focusing in on New York, it's social legislation designed to compensate injured workers for lost wages, a reduction in their earning capacity, or an elimination of it, and also for medical treatment that may be necessary to treat an injury that arises out of an accident or condition that develops at the workplace. The current aspect of the statute that's being attacked is something called permanency impairment or evaluation of what we call schedule loss of use. And that pertains to injuries that involve extremities. So if an injured worker injures their arm, their hand, their foot, their leg, their fingers, their toes, the award that they would get would be relevant to those type of injuries. And as a result, the individual, the injured worker, would then receive an award of compensation that is commensurate with that loss of function. And out of that award, of course, would be deducted whatever somebody would have received or an injured worker would have received while they were out of work due to the injury. So, for instance, to give you a quick example, if someone's determined to have a 10% loss of function of their arm as a result of a work injury, the award may be worth, and I'm going to be hypothetical here, $10,000. If you're out of work for a couple of weeks and you're paid compensation, say of $2,000 while you're out, then when the time came, if the award is worth 10%, the injured worker would receive the balance, the $8,000, as an award in the case. And the injured worker would be entitled to medical benefits for the rest of their life, but they would have, at least for that time, taken the financial aspect or the financial value of the case at that time. And that's designed to compensate the injured worker for the reduction in the loss of function and possibly the reduction in their earning capacity that the injury caused. The guidelines that are used, there are medical guidelines that are used to determine what that percentage of impairment is. And that's right now what's under attack in Albany here in New York. What the guidelines propose is drastic, draconian almost, revisions to the way doctors would apply or assess the residual damage that somebody may have as a result of a work-related injury, which means that an award of compensation, which say may be worth $10,000 under the current regime, may only be worth $1,000 under the new guidelines. Now, again, I'm oversimplifying it, but that's essentially what the new proposed guidelines are recommending. Now, somebody may say, well, isn't the loss of function award excessive? Isn't somebody getting more money even though they went back to work? And the answer to that is that the workers' compensation statute, from the very beginning, was a compromise between an injured worker and the insurance company. And essentially what the compromise was is that you, by accepting workers' compensation, you would forego the right to sue your employer in civil court, where the award can be somewhat substantial. This was designed to compensate for that concession. In general, while the award may thought to be excessive, it really isn't. Because if you look at the period of time somebody's out of work, what their salary may be, and what that award would eventually break down to, it may not compensate somebody for the duration of their life for the reduction in earning capacity or the permanent damage that they have sustained. So it was a compromise even before this, and now they're looking to revise the guidelines that are used to determine what that permanent impairment is to the point where it's virtually eliminated. And that is what's being discussed up in Albany. Now, the predicate of all this is the issuance of these proposed guidelines by the New York State Workers' Compensation Board. There was a task force which put this together, which really the average person or the claimant's attorney, of which I am one, had no access to those discussions or what had gone on in the deliberations to come up with these revisions. We are now in what we call the comment period. On September 1st, these proposed guidelines were issued, which initiated what's called the comment period. So now myself, injured workers themselves, other members of the bar, medical professionals and the like can now submit comments in response to what these proposed revisions would be. And my organization, the Workers' Compensation Alliance, is looking to take advantage of this comment period to advise the Workers' Compensation Board that their changes to the guidelines are extremely drastic. Now, there will be a document that will be issued from my organization, which I will make available, which will actually itemize these changes, and they are quite draconian.
Okay, Joe, a three-part question. You mentioned scheduled loss of use award. What is that? Who's entitled to it? And what's the purpose of it?
Really, what's being challenged is the regulation and the guidelines that medical professionals will use to determine what that loss of function is. And one of the big proponents from the adversaries of the Workers' Compensation Alliance and injured workers is that there's been such improvements in medical technology since the last time these guidelines were revised, which technically I think you can bring back to 1996, since there's been such great improvements in medical technology that the resulting loss of function really should reflect that. But again, I think the predicate for the whole thing is misunderstood, and that is what loss of function is designed to do is assess what residual damage there is. So if somebody has a shoulder surgery or a knee surgery, regardless of whatever the medical technology is that has improved that could create a better outcome for those surgeries, the loss of function assessment is based on residual range of motion. So in and of itself, if somebody has an improved range of motion, then the loss of function award under the current guidelines would be adjusted accordingly without need for revision. So in other words, if somebody were to have a knee replacement, say 20 years ago, that may be worth a 55% loss of function. If somebody has a knee replacement now, if there is the same residual impairment, then perhaps they are entitled to that 55% loss of function or something maybe a little less, depending on what the improvement is in the range of motion. But to reduce it just on its face from, say, that kind of loss of function to practically zero or even half of that is draconian and designed not to provide for any accountability of increased benefit of medical result, but to simply a lower cost, which is, again, something that the statute is designed to provide, and that is compensation for an injury that was sustained on the job. A scheduled loss of use award, again, affects extremities. If somebody has a rotator cuff tear in their shoulder from an accident that they sustained at work, or somebody develops carpal tunnel syndrome in their wrists because of constant use of a keyboard, a computer keyboard at their job, the resulting residual impairment will create or at least provide the basis for what's called a scheduled loss of use award. Each extremity is worth a certain number of weeks worth of compensation pursuant to the statute. So, and I'm oversimplifying it here for those listening, if God forbid you lose your arm, it's worth 312 weeks worth of compensation. So that's 100% loss. So any other injury would then produce a result that's somewhere between 0 and 100% loss of function. And depending on what that percentage is, using the formula that's in the statute, it would determine what the overall monetary benefit would be to the injured worker. Right now, there are guidelines that the medical professionals that do the assessment for scheduled loss of use follow. And for instance, as I said earlier, a scheduled loss of use that may be worth 15% under the current guidelines, under these draconian revisions may be worth 1%. Remember, this is designed to compensate injured workers since they cannot pursue a case against a civil action against their employer. At least, again, I'm oversimplifying that, but the goal here was to create an award to an injured worker that'd be commensurate with their loss of function, their earning capacity, and what future treatment may hold. So to reduce it from, say, 15% to 1%. I think it's self-explanatory. I think anyone who sees that would realize that is a draconian measure. And also the guidelines, as revised, provide for non-medical assessment of somebody's or an injured worker's loss of function. So whether or not that's even appropriate is a whole other issue. But that's essentially what a scheduled loss of use award is and what the current attack is against it. The belief being from the adversaries of the Workers' Compensation Alliance and injured workers in general is that the awards are just are so excessive that that they're too costly to provide. And again, my organization is of the opinion that has no basis in reality whatsoever, and that due to the compromises that were made, which amended the statute to get it to this point, are not being taken into consideration when they consider these revisions. And as time progresses, you'll see that develop in the news and in future podcasts as I plan to hold them. One of the big proponents from the adversaries of the Workers' Compensation Alliance and injured workers is that since there's been such great improvements in medical technology, that the resulting loss of functions really should reflect that. But again, I think the predicate for the whole thing is misunderstood, and that is what loss of function is designed to do is assess what residual damage there is. So if there is somebody has a shoulder surgery or a knee surgery, regardless of whatever the medical technology is that has improved that could create a better outcome for those surgeries, the loss of function assessment is based on residual range of motion. So in and of itself, if somebody has an improved range of motion, then the loss of function award under the current guidelines would be adjusted accordingly without need for revision.
So how can potentially harmful changes to the statute be fought, Joe?
What we could do is, again, lobby, reach out, advise people, educate them on the situation. This is something that every citizen in New York should be concerned about, in as much as it could affect them at any time as if they're employed and they sustained an injury on the job. So the changes can be fought by supporting the Workers' Compensation Alliance. That's either financially or through volunteer service. The other thing that my organization will do will be in attendance at the legislative hearing that's being held up in Albany on this very issue on September 23rd. We will then also seek testimony of individuals that can attest to the nature of their injury, and also from medical professionals that can attest that these new guidelines are not reflective of any increased benefit in medical procedures. So that's essentially how these changes can be fought. We have to garner public knowledge and then have people respond accordingly to the during this comment period, so that when the comments are received, they can seriously be taken into consideration. And as much as quality is important of those comments, it's essential, but I think volume is also essential. The Workers' Compensation Board, as an agency, needs to know that this is not the avenue by which to improve the statute if it does need revising.
Thanks for listening to Workers' Comp Update with Joseph Sensali. Joe is a partner in the Chase Sensali Law Group and is also treasurer of the New York Workers' Compensation Alliance. Join us next time as Joe keeps us updated with what's going on in Albany.